Honorable members, good morning, and thank you very much. I realize that the Parliament program is a bit strange until I think the 20-something or until we close because of the mini plenaries, and that there are members who, apart from this meeting, probably don't need to be in the precinct at all. That's happening to me as well. And then on other days, I'm only involved at 4 o'clock. And they've got nothing for much of the day. So it is a strange period. So I appreciate your patience in being physically here. And I look forward to Honorable Matlala joining us when he can. I understand that he has landed now, but he will join us during the course of the discussion. This is a follow-on to the meeting that we had about the Road Accident Fund, where we resolved to have an inquiry. I'm thankful to the Parliament Legal Services team for assisting us to frame the terms of reference in a manner that is in accordance with the rules and applicable legislation. I couldn't have typed up any of that myself if I tried for a week. So I really appreciate that. I also appended to the email just a note to the committee, a covering note. And I will just, at a high level, reiterate what is important, because we're going to have to say no to a few things, and I'm already having to say that because we are not the Portfolio Committee on Transport. We are the Standing Committee on Public Accounts, and our mandate is quite clear. And it's important that what we do in the end relates to the use or misuse of public funds, or inefficient use of public funds, or maladministration, and so on. I'm saying this because once we finalize the terms of reference, we're still going to have people who kind of want to come and testify, and it's got nothing to do with what we are doing here. So we all need to hold the line on that, because people have all manner of complaints against different institutions. It's important that we stay within the mandate of the committee. The second and last thing I want to say pertaining to the note is that we're also going to have to examine certain things. I think if there was a public discourse that says the Road Accident Fund vis-a-vis taxpayers are getting ripped off by attorneys or whoever, we have to look at that, because it's public funds. So we have to ask for the said evidence so that we can consider it, because what follows is then an instruction to some or other structure to recover the said funds in the event that they were allocated inappropriately or as a result of unlawful actions and that kind of thing. So what I'm trying to say is that the terms of reference have framed in a way that maybe to a lay person might not immediately list a whole litany of issues that you are going to end up looking at. But I think to the members and to the public, so we are going to look at things like that. We have to look at things like that so that we can have a complete process. I am also advised that the preparation is as, if not more important, as the actual inquiry itself. So the quality of the information the committee has at its disposal is very important. Now, while Parliament has the power of subpoena, you don't do that at the first instance. You request the information. In all likelihood, we will get the information, but there might be some people who don't give the information or all of the information, in which we then have to subpoena. There is a process by which that happens, which means just getting everything the committee needs would take a bit of time. But it's important that we prepare adequately so that when we have the inquiry, it is focused, it sits for a finite time, it doesn't go on forever, and we are able to write a report that is useful to Parliament. It's useful to the executive as a whole. It's also useful to South Africans and stakeholders of the Road Accident Fund and so on. So that's our purpose. I just want to be certain that all members have a copy of the terms of reference. Okay, and I'm assuming that we have at least considered them at a high level. What I'm going to ask Denzel to do is to go through each page, because I'm hoping we'll have enough time. We'll go through each page. If there is any member that has got something to raise on that page, then they can say so, and then we keep it moving like that. It's not too long. It's about 36 pages, not Denzel? No, I wanted to freak out Honorable Scots. Where's a time limitation? So that's fine. So if, with your permission, members, then shall we get to it? So that would be the. I don't know if there's a dispute over the covering note, over the covering page. They shouldn't. Yeah, straightforward. Yeah. Okay, on the background section, do any members have a wish to raise any issues? That's section 1, which is the background. Okay. So we're under legal framework now. Okay, Denzel, maybe stop there, and then let's just go through. I mean, I won't mention each one. I just want to be certain. So, the parameters of the oversight inquiry, and this is the opportunity to either propose amendments to add things which might not be here that you feel are important, or where you feel there's a duplication, we don't need to have both sections, and so on. So that's that part of the discussion here. Is your hand up, Honorable Beasley? Okay.
Are we on 4.1.1, or are we moving on to the whole page?
No, you can comment on the entire page. Okay. So you can comment on 4.1. So let's just start with 4.1.1. Okay. Let's do that. Then it's more efficient. Does anyone have anything to raise on 4.1.1, which is governance failures at the RAF, the adequacy of oversight by the RAF board over executive management, the recruitment, vetting, and appointment processes for senior officials, the finalization and implementation of the RAF's organizational structure, and the financial implication of the same. So that area that would cover a lot of ground. So in other words, that's an assessment broadly of the board, and as the function that approved the restructuring of the RAF, where the vacancies subsequently emerged, it's still the job of the board to make sure that the structure is implemented, because you can't implement the strategy without the people to do it, and that's why that is there.
Yeah, so Chair, my point on that is also maybe we go one step up too, because ultimately the Minister of Transport should also have an oversight and some type of responsibility too. So I don't know whether we just leave it at the board, because we've actually got to go one step either. And the Minister of Transport, where they've been in the last couple of years, and with adverse audit reports and all of this that's going on. So maybe we just need to take it one level up too.
I have no opposition to that proposal. So the proposal, members, is that it's not just the board, but the minister also, as the person with executive oversight over the organization, needs to come and account. So that is one proposition. Honorable Atkinson?
Chair, it's in line with that comment about the minister's responsibility. And it also, in a sense, I'm jumping ahead as well, because I see that this covers a period from 2021. So I think we shouldn't only be calling this minister, but we should be calling the previous Minister of Transport as well to account. Yeah.
All right. Do any members have any opposition to that? I don't. So is it something that we then note? Honorable Neil May?
Good morning, Chair. Good morning, colleagues. In the addendum, the persons listed for to appear before the Minister Creasy is there. Would we then just add the previous minister or those that we are saying need to come to the addendum? Because we're not going to change the governance failures. Is that what you're saying? Or we're going to put a point here that also looks at the oversight with regards to the oversight from the Department of Transport?
No, thank you. I think what might suffice in the context of the addendum is to say the adequacy of oversight by the ministry and the RAF board. Right. Then that should solve it.
Yeah, Chair, just another little issue. I think a lot of us have seen the suspended chairperson's been on the news a lot. It's been on TV and everything, in contravention of his suspension requirements. So, I mean, he really shouldn't be out there. And in a sense, he should be called to account by the board. The board should actually be sending him a letter telling him to cease and desist. We don't know whether that's happening or not. So I think with regards to the oversight that they had, they also have kind of a managerial responsibility over him as well, I guess, or a responsibility to stop him from acting outside of the bounds of his suspension. So I don't know if that's covered by this, but I think the stuff that's happening now should actually be looked at as well, because he's because of the contraventions of the law and the apparent absence of the board in this instance.
Thanks, Honorable Atkinson. Look, I think for me that all falls under that topic, because we can't itemize there absolutely everything, right? And part of the reason for this exercise is that we also not seized with RAF matters every day. We're going to fall behind on the rest of our work. So I think that would, and then at the appropriate time, it's something that we would then deal with. That does not mean when issues arise on an ongoing basis, we don't raise them with the minister or or the board. All right. So are you a member?
Honourable Chairperson,
No, thank you very much. No, this so you can't participate in these proceedings. What you are permitted to do is to send a written submission to the committee following your observations here, because there will be an opportunity for people to do that. Thank you. Honorable Kupeka.
Thank you, Chair, and greetings to the House. Chair, I have not read the entire document, so I'm not sure if I'm speaking out of turn here. With the parameters of the oversight inquiry, is it possible for us to look into the legal firms that are now forming part of the companies that are no longer getting paid by RAF, and the monies that they had actually been paid previously versus the money that they're being paid now? Is that possible?
No, you're not speaking out of 10. You're just too early in the discussion. Okay. So there is a section later on that deals with legal costs and that sort of thing. So it's covered.
It's covered.
Which is why I emphasized it in my covering note to members that we will. So that slide that was presented to us, if you remember, so I said they will be required to give us specific information by legal firm, not just a list. So I'm hoping that covers you. Okay, thank you.
Yes, thank you, sir. That does.
Sorry, can I ask, so we've got Parliament Legal Services here to advise us. So I see a hand is up. So I'll come to you, Honourable Skosan.
Thank you, Chairperson, and good morning to yourself and the honourable members. Chair, just on the question of whether the committee can invite the former minister, Parliament can, of course, invite or, if necessary, summons any person, whether that's a private person or an official or a public functionary, to appear before the committee, provided that it's necessary for the committee to fulfill its oversight functions. So your first port of call would, in fact, be the current minister, and to see whether the current ministry is able to provide the information that the committee requires. And only in the event that they're not able to do so, may we call upon the former minister. That would be my submission. I suspect that the former minister's position may be that they're not in possession of the records that they may require, and they may refer us back to the current minister. So unless the committee can put together very specific areas that they wish the former minister to comment on or to provide evidence on, and specific documents that would be in the possession of that minister and not in the possession of the ministry as it currently stands, it would be better for us to first target the current minister, Chair. Thank you.
All right, thank you very much. I think your guidance, therefore, is that anything with regards to ministerial matters, the incumbent minister must account for whether they were there or not. However, if there's a specific, so in other words, it's within the personal knowledge of the previous minister and not this one. In that case, the previous minister must then assist the inquiry with that specific piece of information.
That's absolutely correct, Chair.
Thank you very much. I'll come to you, Honourable Skosana. I'll start with this, Honourable Skosana, because his hand was up first, and then I'll come to you.
Thank you, Chair. You know, I must just make a disclaimer as well that the issue of inquiry, for me, doesn't make sense. But that's a debate for another day. Because it's a costly exercise. I can tell you now that already there's people line up. You know, it's the same thing. We've seen this before, and I'm going to say that I'll be vindicated at the end of the day after this inquiry, because it's all about numbers here. The issue of it is a very costly exercise. If I may ask here, how much is that? How much is this inquiry going to cost us? When I'm saying us, I'm talking about taxpayers' money.
No. Can I say that?
I just want to finish off.
That was a debate for last week.
No, I understand that. Hence, I'm saying I'm not. But the disclaimer I've made that, because
Okay.
even if I'm saying I'm not. It's all about numbers. I'm not going to win that, so I don't want us to go there. But what I'm asking is, let's get as well, how much is it going to cost the taxpayers' money? Thank you, Chair.
So can you switch off your mic so that I can answer?
Yeah.
So this is going to be a member-led process, which means in the main, we will do the work that we are paid to do ordinarily. So none of us are going to get paid extra for it, however long into the night it goes. That's the first thing. No, I want to I want to itemize everything. The second thing is the legal advice that we are getting is entirely internal. It's people who get paid what they get paid. That's the second thing. No, you asked a question, Honorable Skosana, I'm answering. Okay, so that is the second thing. So that is the second thing. The third thing is that all the attendant costs, the venue and so on, we will hold that hearing here in Parliament. The only thing we might need to do is for the committee to get expert advice or expert explanations from somebody from outside where it is necessary, in the event that it is not available from within the government, in order to assist us with the proceedings and so on. So there is going to be no extraordinary cost here that Parliament incurs. Additionally, because we've got other oversight work that we do, I have agreed with the House Chairperson, as I said in my letter, that will be allocated from within the Parliament staff additional people to carry on the weight. They will come from within the Parliament staff, so that we are able to do so. I don't have a number now, but to the extent that there's additional cost, it will be minimal. The second thing is that the state entities that must come and account here will then bear the cost of travel and accommodation and so on, as they do whenever they get called to Parliament to come and account, however many times a year. That we have an inquiry does not make that an additional expense. It means we want to focus on specific things for a specific period of time. I don't know if that answers you, but this is a member-led process. We're just choosing to get all the information, set time aside to deal with the matters and be done with it.
Okay, if I can make a follow-up quick.
But the point I wanted to make is we're dealing with the terms of reference now. What you and I are having a debate about is outside of the terms of reference. Can I suggest that to the extent that you've got issues outside of the terms of reference to raise, we do that once we finalize the terms of reference?
No,
because
you can go ahead, Chair.
What you are saying is not in the terms of reference.
Yeah, but what I'm saying, as I said, I was making a disclaimer to say, Chair, even if we rush, we go terms of reference, I've seen this thing before. And I'll be vindicated. I'm still saying that to you. You know, the state attorneys, there's a legal team here in Parliament. I can rest assured you, Chair. What we are saying now that it will be minimal is a pipe dream. Thank you.
Thank you. Accountability has a cost that it has. South Africans have this institution to extract accountability out of members of the executive and agencies. And I think people accept that, but I take your point.
Because the Zondo Commission, as we speak here, other people are saying it was a wasteful expenditure, and I agree with them. Thank you, Chair.
Thank you, Honorable Skosana. Honorable Skosana, the second Honorable Skosana. This is a familiar affair.
No, thank you very much, and good morning to everyone. Yeah, I just want to comment on that 4.1.1, the first bullet that we are seeking to amend to include the ministry, because I see that the Secretary has made some amendment there. My view is that we need to maintain that bullet the way it was. That says the adequacy of oversight by the RAF board over executive management. Then after that, create another separate bullet that speaks about the ministry. Because if you add the ministry in the same bullet, it suggests that the ministry and the board, they are playing the same oversight role over the executive, whereas the role of the ministry is different, because the ministry is playing oversight on the entire institution, including the board itself. So we should have a separate bullet that talks about the role that should be played by the ministry in the institution. Thanks.
Thank you, Honorable Scott, and I think that's sensible. I think that is sensible. Thank you very much. So, Denzel, please make a note. We must amend accordingly, because the minister interacts with the board interacts with management. No, thank you very much. Shall we go to 4.1.2, financial management and compliance, and that is allegations of irregular, fruitless, and wasteful expenditure, compliance with the PFMA and related financial regulations, the RAF's cash flow management, including allegations of deliberately failing to make payments of claims as due in contravention of the legislation, and the RAF's failure to fully disclose the cash earned, the management of its cash equivalents, and the specifics of its investments and the amounts invested. This comes almost entirely from discussions we have had in the committee. So what I'm about to do is to remind members where this comes from. So the irregular, fruitless, and wasteful expenditure, a little bit of it, and in fact, let's leave the procurement issues are coming next. When an entity, any entity, is supposed to settle an account and they don't, and that account accumulates interest, the Auditor General ordinarily regards the interest that the entity has paid as fruitless, as wasteful and fruitless expenditure, if you recall. Same issue with municipalities and so on. And in this instance, what we know is that the RAF has a lot of matters where there's interest accumulated through default judgments and writs that have to be obtained. So that is the first one. The second one is compliance with Public Finance Management Act. I think that's clear. That's a framework in which we work, and I think maybe we just swap them around. Let's start with the PFMA and then do the fruitless and wasteful expenditure. And then the RAF's cash flow management, including allegations of deliberately failing to make payments. Let me remind members, this is from March. This is from during my interaction with the RAF board and executive, wherein I asked about the amount of interest the Road Accident Fund had earned, which was close to 700 million, if not 700 million. I then indicated that my concern is that the Road Accident Fund runs high cash balances for most of the year and then pays out the claims only in the last portion of the year. I said that the members can consult YouTube and the record. I asked the question. The Chief Executive Officer of the Road Accident Fund said that is exactly what we do. He gave a reason for it. He said that is to manage the 180-day payment period. Now, there are contradictions in the answer because you can manage your cash flow without running cash balances of between 9 and 11 billion. And I gave the number to the chief executive at the time. So we need to look at that because it relates to the first point of the interest that accumulates while you are withholding cash and you end up incurring fruitless and wasteful expenditure. That came from the committee. So I just want to explain where that comes from. Then the failure to fully disclose cash and the management of its cash equivalents and the specifics of its investments and amounts invested. In the same conversation, here in committee, I asked, where are those investments? Because there was a contradiction. I had asked in October last year about the cash and about the chief investment officer and the treasurer, that conversation. I asked what those investments are. They said it's a call account. In March, they said they are investments. I asked the question, where is that money invested? The answer was, we cannot tell you where that money is because there are people that are looking for it. So I just want to say this does not come from thin air. This was a conversation that is on the record here in committee. Now, the point I made last week is that if the PIC came here and we asked them, where have you invested public money? And they said they couldn't tell us, I think the members would not accept it. I said the same thing last week. The chairperson of the board was here. The deputy minister was here. Everybody was here when they said they couldn't tell us. So that is why you've got that section. So it doesn't come from thin air. I just want members to have the background. Honorable Atkinson.
Chair, just an aside comment on that, and I'm not sure if it was dealt with when we discussed that, but is a state entity actually allowed to have such huge cash balances? If they have that kind of amount of money available, should that not be sitting in the South African Revenue Fund with Treasury, basically?
Thank you, Honorable Atkinson. So I sought the counsel of the Director General of the National Treasury. And the Director General said to me, that's prior to concluding the memo that I shared with the committee. The Director General said, unless the legislation specifically allows an entity to do that, all cash reserves must, not should, must be deposited with the Corporation for Public Deposits. The Corporation for Public Deposits sits in the South African Reserve Bank. The difference between that and the Public Investment Corporation is that the Corporation for Public Deposits does short-term money market type investments because the entity might need the money tomorrow or the day after, so it needs to be readily available. And the long-term asset allocation is for the PIC because you're looking at capital growth, you're looking at dividend income and so on. None of that are in the mandate of the Road Accident Fund. In fact, which is on our to-do list, there is another entity that is sitting with 50 billion rand in its cash reserves. It is refusing to transfer it to the Corporation for Public Deposits. That's not the issue for today, but it's on the agenda of the committee because it must be. The law is the law. And so that's where it needs to sit. Now, part of this inquiry is to ask, but why are you not following legislation and doing what the legislation says you should do? First of all, where is this money? Why are you not using what legislation says? Show us a proof of what you've invested, etc., etc. So that's what we need to do. I just thought I should clarify that. So I did ask in case I'm mistaken. That's how it works. Thank you. Honorable Beasley.
Thanks, Chair. Also, if we can put under financial management and compliance as the RAF failures to implement accounting policies as per the Auditor General. And because I think it is a big issue, and I think we got no idea of what the liabilities of the RAF are. So somehow if we can bring those two into that particular point, why they refuse to implement the accounting standards.
So it is somewhere. So Honorable Beasley, so let me just say this. We have canvassed that issue in committee. They did say why, right? So we understand that. The issue in the context of the decision we took on the inquiry was the manner in which then the board and the executive acted upon taking a decision that the accounting policy does not work for them. And they've incurred expenses in pursuit of what could be an unlawful action. What do I mean by that? What I mean by that, as I explained in the memo, is that when you are unhappy with the application of a legislative mandate by an entity, you approach the courts. You may approach the courts. ESCOM has done that. I made that example. What you don't do is to proceed and do your own thing, even though you don't know what the outcome of the litigation is, because then that's it. So it's under a different area, and I'm not sure it would serve us to examine why, because the matter has been litigated, the facts are set out. What is set for us to determine is whether the expenditure was lawful and justified and not reckless and wasteful. I don't know if you get me.
I do, Chair, but I think the big concern is that there are liabilities that aren't disclosed, and that has a huge impact on the stability. I mean, the liabilities could be as big as Transnet. We actually don't, nobody knows. And I think we would be reckless if that didn't get some type of attention somewhere in our investigation.
Okay, let's just hold that up. Can you just scroll down, because I do think it is, it might be covered somewhere. That's what I'm thinking. Fraud, whistleblower, automation. Okay, there's that. Just go on. Yeah, go on. Okay. Okay, I see. So it is not specifically covered. So let's do this, right? So there is a related issue. So it might, in fact, we don't need to debate the substance of what you're saying, but you are reminding me that there is another area that the committee has to look at, because there is a possibility that there's, in any event, misallocation of accounting entries as a consequence, and I'll explain that. All I'm saying, Honorable Beasley, and I'm going to give the members an opportunity, I think the why we know. We know why. They've stated before the committee, and their reason is their reason. What we need to determine is whether the expenditure of funds in the way they did in pursuit of their decision was lawful or not. Are you suggesting that we debate the core reason?
No, Chair, I don't know if I'm getting my point across, but my concern is there's a huge liability in the RAF that hasn't been quantified, and it's not covered in this actual report. We can talk as we like about fruitless and wasteful expenditure, but if there's a massive liability that's building up that's not covered, that is my concern.
Okay, so maybe we should do this broadly, and I'll explain why we broaden it. So one of the things we must now look at is whether the accumulated interest on outstanding claims, anyway, that's another example, on outstanding claims, is correctly entered into the books as a liability, because it becomes a liability. Unless I'm getting this wrong, but it becomes a liability. So firstly, I'll come to you, Honorable Skosana. So it becomes a liability. So maybe what we need to do is to frame it in a way, and I might not have the language now, is maybe the accuracy of accounting entries in relation to the road accident funds liabilities, because there are other areas. What I want us to be careful not to is to have the theoretical discussion again, because that's been ventilated. The courts have decided. So the courts have said they don't have a case. Is that fine? So the bullet becomes we're looking into the accuracy of the statement of liabilities in the financial statements. That then covers the other issues as well. All right, thank you. Honorable Skosan?
Yeah, what I wanted to check, Chair, are you talking about interest?
For me, you mean what I said?
Yes.
Yes, yeah.
Yeah, so perhaps I don't understand well. Remember in the last meeting when we were here, there was that issue with lawyers that what happens to the interest of the 350, those one who were double paid, you remember? Yeah, now, and they explained, in fact, they were trying to run away from it to say, really they are not, no one can force them to pay that money. In fact, that debate ended up nowhere to say whether that interest will be taken from them or not. Now, in case of REF, as we are saying, the money sits elsewhere. I just want to find out exactly where that money must go, the interest itself. Who must get that?
So in fact, there are two issues, and we must make sure that they're adequately covered in the terms of reference. There are two issues. So, Honorable Skosana, there are two, the main interest, there are two interests that we're talking about here. The first is that when a claimant obtains a court order, and that court order is not complied with within the time that the court has set, right? The claimant is entitled to interest that is being compounded. I think it's set a daily rate. Is it a daily rate in terms of the court rules? But it's compound interest until it is equivalent to the same amount that they're claiming. In other words, if they don't pay you long enough, what was a 3 million award could become a 6 million award. That's the one part of the interest, right? The second part where the double payments are concerned, right, pertains to funds that the attorneys that were double paid did not pay the money back in time, one, and secondly, therefore the interest they earned in the time yes. So there is a section 4.1.4 under legal and litigation expenditure. So we're gonna need to maybe just do something there, but what we need to look at there is the RAF's own expenses on its own attorneys, and then the legal costs presented to us as being plaintiff costs, right? What the Road Accident Fund will get an opportunity to do is to break down in detail each of those two columns so that they can then state and say we are owed this much by the following law firms for the following reasons. So that if that presentation substantiates the point, the next question then is what steps are you taking to recover the money? So I hope I've explained. Yeah.
Why I was asking that, Chair, maybe because some of us, we know what is happening on the ground. You know why I was asking about that? The issue, Chair, is that some claimant as well are happy that the ref are not paying them in time to exactly get the compounded interest. And what happened is that, as you know, that it cannot be over the initial amount. Say, as you make an example, 3 million interest can only goes up to another 3 million. Up to that, some of them who are comfortable, they stay long to make sure that that money makes interest. In fact, they are happy to do that. To say, okay, there's a court order, you're not paying me, it's fine, no problem. You know, they stay for long because they've got advices to say, by the time they comply to the court order, your money is no longer 3 million. It's exactly what you said. It's 6 million. Thank you, Chair.
Thank you very much. So I think, Honorable Scosa, now there'll be opportunity for the Road Accident Fund to explain all of that under 4.1.4. Yeah. I just want us to complete the financial management and compliance section. Honorable Scosa.
Yeah, no, thanks, Chair. No, I'm covered in terms of your response to what the Honorable Beasley was raising. But more and above that, I think 4.1.2, bullet 2, compliance with the Public Finance Management Act and related financial regulations. I think broadly it covers a lot of issues that relates to financial irregularities and so forth. So where we are not specific to certain matters, I think that bullet is going to assist to cover us, including the matters that Honorable Skosana is also raising. Thanks.
All right. Thank you and thank you very much for that. Let me come to Honorable Isaac, then I'll come to you, members.
Thank you, Chair. Chair, okay, so on 4.1.2, are we agreed that we would maybe bullet number 2 would become bullet number 1, and then bullet number 1 become bullet number 2? Fine. And then just a thought, and I'm responding to Honorable Beasley's suggestion, and I think it was, a quality comment, in that something we need to keep in mind. But with due respect, if I look now, and I hope I'm not jumping the gun here, but if I just scroll quickly to 5.3 and consider the issue there, 5.3 seems to also have a bearing in terms of covering what Honorable Beasley's suggestion was. So I'd just like to get your opinion, and I think it's all in there. If you go to the third sentence, where law or applicable financial regulatory prescriptions, this includes most importantly the Public Finance Management Act. It's just an opinion I just wanted to express. Thank you, Chair.
Thank you very much. I think it does bolster the point. Thank you. Thank you. Honorable Neil May and then Honorable Beasley.
Thank you, Chair. With regards to on the financial aspects, would we be putting the aspects of the security procurement under procurement, or would we look at what the financial, how much did that actually cost? I mean, if you saw the front page of the Sunday Times, you could not miss it. And it's a huge amount. And the same with the, obviously, So basically what I'm saying is, could we not have, on financial, we need to look into the procurement of the security and the BMW that is armor-plated somewhere. But I mean, maybe the total amount of money, that's what I was looking at, not so much as the process, because we know that there was no deviation, we know there was no approval, we know there was an investigation by the board, but I think just the amount, how much is the security, and is that the only security that we don't know about that is at RAF?
Thanks, Honorable Neil May. So it will come under two parts. It will come under 4.1.1, which is the oversight of the board. The reason and it also comes under 4.1.3, which is procurement and supply chain management. Here's why. So when I saw the article in the Sunday Times, I went back to the sworn affidavit of the chairperson of the Road Accident Fund in the litigation about the suspension, where she quantifies the security allowance at 480,000 rand a year, right? So we have to square that and the reported amount. So there will be a bit of interactivity in the process, in the sense that if the board has signed a contract with any executive employee, with the chief executive in this instance, and it sets certain parameters, you then have to understand how the deviation was achieved. Then you end up you look at the supply chain issues as well. So now that it's in the public domain, we'll look at it. I did go and look because I could remember that there was a reference to security and that sort of thing. So I think it's adequately covered. Thank you. Honorable Beasley.
So, Chair, I don't know if we've got an agreement there, because I thought we did that there'd be a bullet point saying the completeness of liabilities.
Yes, that's what we'll do. Yeah.
Okay. And then with all due respect to Honourable Isak, 4 and 5 talk to different matters. So we're talking specific issues here. So 5 talks about something else and 4 talks to something else at different points in the report.
Thank you very much. May I give Parliament Legal Services a chance to...
Chairperson, just to assist Honourable Beasley, the way I've captured it now is failure to, so a new bullet point, failure to comply with accounting standards as directed by the AG and the non-disclosure of liabilities, including the accuracy of accounting entries to properly reflect such liabilities.
Thank you so much for that assistance. Honorable Madlala, you can actually come and account on this side. You don't think so? Yeah, the gentleman hasn't answered any questions yet, so it's nice that side. It's very nice that side. Honorable Atkinson.
Sorry, Chair, just a little bit further on that security contract. My understanding was that when the CEO got suspended was that he was meant to hand the security back as well, literally, that the security didn't continue after he was suspended. So, I mean, that might be another interesting point to look at as to why that does continue after suspension. Just an aside, yeah.
All right, thanks. Look, what Parliament Legal Services will assist us with is how to scope our requests for information such that they are within the scope of the inquiry, and so that we can deal with all matters that are relevant to what we're doing. Honorable Skosana.
Yeah, in fact, Chair, in my experience with all the people who are suspended with security, who are suspended, when they have security, the security continues. Thank you.
Thank you. Look, Honorable Matiwane, I skipped you. Look, colleagues, the inquiry will assist with us with all of this. So, and I have skipped you, Honorable Matiwane. I am so sorry. My apologies. I think you should start banging the table.
No, Chair, there's no need for banging of tables. We can make our points without banging tables. No, I just want to caution the committee, because we are dealing with the terms of reference for an inquiry. So what we're supposed to be doing is supposed to be scrutinizing the terms of reference. Where they are lacking, we add, and not trying to preempt the inquiry to seem as if we have predetermined outcomes of what the inquiry will say. Because the entire reason why we are having an inquiry is for us to understand issues that are not clear to us. Because now the way that we are debating now, it's like we are in the inquiry itself, where we are adding allegations, because allegations remain allegations until they are tested. And the reasons for us to have an inquiry is to test allegations. Because now the way that we are going on, it's like we are already in an inquiry, or we have predetermined outcomes of what the inquiry will tell us. So I'm just worried about that.
Thank you. And I think that's a very important intervention, colleagues. So what's important is, look, to the extent is that a member may need clarity on whether an issue is sufficiently covered. I think we may seek that clarity, but what we can't do is to debate the issues here, and that just like us to us members, to that we confine ourselves to the adequacy of the terms of reference. And I wish to remind members again, we don't have a limitless scope. There are things that will fall outside the scope of the mandate of the committee, and we must be happy to exclude those. Not that we don't want accountability, but like I said, for example, we are not the Portfolio Committee on Transport, which might be empowered to deal with certain other matters pertaining to the Road Accident Fund. So we must remain. And the last thing I want to say, which arises out of Honorable Matiwane's intervention, is that this is an inquisitory process. That's the point he's making. It's an inquisitory process, not an accusatory process, which means we are inquiring, we need to get all of the information, synthesize it, reach conclusions. And it's important that we maintain that spirit as we have our deliberations. Thank you. Thanks, Honorable Matiwan. Okay, so can we move to procurement and supply chain management? 4.1.3. So the only thing I want to say there, colleagues, is that, and I'm going to look at Parliament Legal Services to guide us. I don't think we want to conduct wholesale review of every contract at the Road Accident Fund. My proposal would be we limit ourselves to issues that we have either received written, whistleblower accounts, or matters that have arisen here in committee one way or another. Because I don't know how much procurement the Road Accident Fund does. If we were to go and scrutinize everything, the inquiry will go on for years. And I don't think we should do that. So I just want to be certain that the scope of what we look at there has to be a specific reason why we're looking into certain things rather than doing a wholesale review. If out of the inquiry we feel that what we've seen gives us discomfort about other things we have not seen, the Auditor General is available to the committee, that we ask the Auditor General to look into that area. That's what I would like, so that we've got that understanding. Otherwise, also in terms of members of the public, we might just end up getting 600 emails, which also defeats the purpose of what we're trying to do. Would that be, let me just ask Legal Services. I don't want us to have an unlimited scope here.
Yes, Chair, that's exactly correct. Chair, the nature of this oversight inquiry is that it would differ from a statutory inquiry or constitutional inquiry that leads to a specific outcome. For example, the removal of a Chapter 9 institution head, or the removal of the president, if we were inquiring into that. So the aim at the end is not to necessarily reach a conclusion that this person ought not to be in that position, or that this was definitely a criminal offence. A lot of the recommendations are going to be referral to the appropriate bodies to deal with it. So certainly the example that you give, we would then refer to the AG and perhaps request a special audit in terms of the AG's power to conduct such a special audit if we are of the view that there are reasons to justify same. But I agree, Chair, that we need to pick specific contracts, perhaps the ones with the biggest spend. Those would be the ones automatically that you would apply your mind to and then take it from there.
All right. Thank you very much. And I'm just hoping the members are quite clear. Yeah, thank you. Also, don't want us to look like a witch hunt where you go and look for a problem until you find one. Okay. Thank you very much, colleagues. Is there anything else? Honorable Matiwan.
Thank you, Chair. I don't know if bullet point number 3 will cover the panel of attorneys, because I think it's one of the issues that we need to get an understanding of what was happening there and the rationale from the Road Accident Fund for cancelling that contract or ending that panel of attorneys. So I think we should also scrutinize that so that we can get to the bottom of what is happening, or get an understanding from RAF on why they saw a need to do away with the panel of attorneys.
All right, thank you very much. You know, members, I'm actually going to rely also on Parliament Legal Services, and let me explain, at least in setting out what the issues are, what I was stuck in. On this very point, Honorable Matiwan, that part of what we also maybe ought not to do is to duplicate work that is being done where Parliament is receiving reports, right? The SIU is looking specifically at that matter, and the SIU accounts to the committee on its progress on that investigation. And therefore, maybe we'll need advice on how we deal with it. It is a pertinent matter because it does have an impact on the cost escalations at the Road Accident Fund. And perhaps we need to define how we deal with that issue without replicating the work that the SIU is already doing, if you understand what I'm saying. So I must admit, I do need guidance. It's a good point that you are raising, that we give an opportunity to the Road Accident Fund to set that out, but part of that inquiry is understanding the cost implications thereof, which also falls in the ambit of the SIU. So I'm placing that on the table. Honorable Kupek, and then I'll ask Parliament Legal Services to assist.
Yes, thank you, Chair. I'm just thinking here, Chair. I think part of this inquiry as a whole is to assist the RAF. I think that's the long and short of it. When the first time when RAF came here, there's something that they said that still troubles me to this day. I think it was the CEO who said, people can be in South Africa illegally, but constitutionally so. And when they are here like that and they claim through RAF and they are here illegally and constitutionally like that, how do we assist RAF speak to that issue? And I understand, Chair, that what we're dealing with here is specifically mostly financial issues, but a large part of those financial issues sit with issues like a law that would say people are here illegally, but constitutionally so. So when we do what we are about to do now with this inquiry, are we going to be looking at that, or would we be within our would it be within our scope to look at an issue like that? Thank you, Chair.
Thanks, Honourable Kupeka. Let me ask Parliament Legal Services to assist us with the first point. So the issue is the SIU is looking at exactly that question. They provide updates to the committee on a regular basis, and that was what I couldn't figure out in my mind how to frame, at least in the terms of reference. I need your assistance because it is an important issue, because there are cost escalations as well for the Road Accident Fund as a consequence.
Thank you, Chair. Chair, the mere fact that another organ of state is dealing with a particular matter doesn't mean that the committee is excluded or prevented from dealing with the same matter, because the roles and purposes is very distinct. So nothing would prevent the committee from looking at it. I do think the committee has already received an answer on the question. The question has been posed to the RAF, and they've indicated that the reason that they got rid of the panel of attorneys was as a cost-saving measure, because it would have been cheaper to go via the state attorney. Whether that is factually correct or not, obviously, that must still be tested. I do think, though, Chair, it will organically come into the evidence when we deal with the very first bullet point on the governance failures, and particularly the fact that that legal services department wasn't fully equipped and there were key positions there that weren't filled. So I think that evidence related to this, you're going to end up hearing it, and we can certainly ask questions when the time comes.
Thank you. So may I make a suggestion? I take the point that you're making. May I make a suggestion nonetheless, so that it is clear? My worry is that we may not provide an adequate opportunity, and perhaps it's under the legal expenses section, right, that we add a bullet that says, please just go up, Denzel, to the legal. Go lower, legal and litigation expenditure, right? So maybe the first bullet should be that to look into the extent and the reasons for the road accident funds legal or legal costs or legal and related costs. If we do that, it helps us to cover that, because there are other issues as well that arise. So I don't want us to leave it leave it in thin air and say it will come up. That will then give the road accident fund the opportunity to say, in thinking about our legal costs, these were the things that we considered, these were the decisions that we took, and then provide the necessary evidence, and then we can look into those matters because they arise therefrom. I don't know if I'm making sense. Would that be helpful?
Chair, more important than the reasons is for the committee to consider the financial impact. Nothing in law would prevent any entity from determining that it would be better suited to use one method instead of another. So I think the focus should rather be, and this is the way I've captured it now, the financial impact of the decision to use the state attorney in favour of a panel of attorneys. Something along those lines, because perhaps the numbers show something different to what we're assuming.
All right, thank you very much. So basically, we just say the financial impact. What that financial impact is, we will then be presented with in the inquiry, and we can reach a conclusion. Okay, I think that's helpful. So we will frame it like that, so that we do address the point and we don't leave it hanging. I don't know if that helps. So sorry, Honourable Skosa, are you still on this specific point? Because Honourable Madla and Honourable Kupeka had two parts to his, and I need us to deal with the second part of it and not forget it, if that is okay. So the second part of Honourable Kupeka's intervention pertained to the issue of of non-South Africans or illegal immigrants or unlawful immigrants to South Africa, who then submit a claim, and the Constitution allows that they do. So let me place this on the table. So since we said we're doing an inquiry, I have, for instance, received a letter from a representative of medical aids, right? My consideration of the letter is that it is asking us to get into a territory of either the litigation that is ongoing or the job of the Portfolio Committee on Transport. In that I could not see in it where, in terms of the advice that we've got, we'd end up with a conclusion that, so basically their gripe is their members are losing out. Now, I don't know if it's our job to work out whether their members are losing out. The matter is in the courts, number one. Number two, we are concerned with losses to the state. Resolving the legal matters involved in that issue is not, I think, something that I think we are competent in. Similarly, with the issue of foreign nationals, Honorable Kupek, I don't know if we can resolve. I think the Portfolio Committee may decide that, you know what, we need to change the law, for example, which they are quite empowered to do. So I don't know. I mean, I'm placing the dilemma on the table because the two fall into a similar category. They don't, in the end, go back to what we are dealing with here, which is the efficient use of government money. But can I ask your advice if that's okay?
Chair, that matter doesn't deal directly, as you say, with the allegations and the scope of what this inquiry is about. And nothing prevents the committee from making a referral either to the Portfolio Committee or, for example, to the Constitutional Review Committee to say, look at this particular issue, because that issue that's being raised now obviously has constitutional implications. But it's not something that I would focus on as an exclusive area here, because I can't see that it's tied to any of the allegations as such. That is just a factual matter that, as things currently stand, that these payments are made to foreign nationals. So that is something I would think that the Portfolio Committee would be better suited at dealing with. But nothing would prevent the committee in recommendations to say that during the hearing it's come to our attention that X amount is spent on this, and we are concerned that expenditure is too much and it could be curbed through legislative review, and that has to be considered elsewhere.
Okay, then may I propose the following then, in light of that advice, that perhaps I don't think it's something that we litigate as a standalone, that to the extent that this is an issue and the RAF looks at the state, the impact on its own finances and that kind of thing, they feel that it's an issue they need to raise with the committee. We provide them with the opportunity to do that. We are just not the committee to solve it. The committee to solve it would be the Portfolio Committee on Transport, the Constitutional Review Committee, etc., etc. So, but that opportunity, if the RAF wishes to ventilate that matter, then is provided. I don't know if that suffices, Honorable Kubek, because we're limited in what we can do given our scope.
I hear the legal advice, Chair, but I've got a bit of an issue with it, in that whatever it is that we're looking at here, we're looking at mismanagement of funds and how funds are spent. And if it's government money that is being spent in a way that this committee sees as something that is a wasteful expenditure, paying foreigners is a wasteful expenditure, as far as I'm concerned. But I will take the advice of the House and we'll continue. Thank you, Chair.
No, thanks, Honorable Kupeka. Look, I don't think we can accuse the RAF of mismanaging if they are forced by the law to do it, right? Yeah, so we can't, however, it's something that needs to be looked at. Yeah, okay. No, I thank you for that. Honorable Skosan?
Thank you, Chair. You know, it reminds me when someone says law is the law, the execution of Solomon Mahlangu, the judge said it's the law of the country. And we know today that was completely wrong. The law can be wrong as well. I mean, the issue that illegal immigrants, constitutionally, for me, the courts as well, as you said, perhaps not on this forum, on another forum. I was shocked as well to say, you are illegal, but constitutionally you are. What was that? What was that? We can't. I mean, we are lawmakers now here in Parliament. Though it's all about numbers. But we can't be ruled by 11 people in this country and say law is a law. If they are wrong, we must tell them that they are wrong. We must amend this law. Those powers were given by the voters in this country. It will depend in Parliament whether do we agree or we don't agree. But the issue is that when something is wrong, we must say it here. Whether it's the Constitution says that, which now poke the issue about the Constitution in this country that is the best in the world. Now we are finding out that is not the best in the world. It's the best for those who are privileged, maybe. But for us, taxpayers' money, how do you pay somebody illegally and say it's a law? It's nonsensical, to say the least. Thank you, Chair.
Thanks, Honorable Skosana. So I will say, the beauty of our system is that the judges cannot create something that this parliament cannot apply something this parliament did not create. So it's never their fault. it's never their fault. They're doing what we as legislators have told them they must do. So that's the first thing. In the event that any of us feel that a law or the Constitution don't work, it's really within our power to then facilitate the necessary amendments to do. No, thank you very much. I'll come to Honorable Atkinson and then you, Honorable Beasley.
Chair, in all honesty, as you said earlier about the medico-legal claims and them not being, or the medical aids not being paid, and the issue of foreigners, I mean, it's not really in the scope of this committee because it's actually a policy issue and it's something that should be dealt with by the Department of Transport. So when they rewrite the RAF legislation, it's something that they should be looking at. So I don't think it's something that we should be debating at the moment in this committee. Thank you.
Thank you very much. Look, I think there is a specific limitation that we've been given, which is to the extent that the RAF wants to show impact on its financial state, they can. Right? What we recommend thereafter is up to us, but we're not litigating the constitutionality of it. They may say that, look, one of the things that's putting us in a bad financial situation is XYZ. Thank you. Honorable Beasley.
Thanks, Chair. Just moving on under 4.1.3, do we need to specify what areas of procurement we're particularly worried about in terms of contracts, just if the legal can give, just for my own education, because it's quite broad. So when people come here, they're going to say, well, we don't know. So do we need to specify 1, 2, 3 areas that need to be looked into? Thank you.
Yes, that was the advice. So there are two things. There are questions that arise out of information supplied by the RAF. There are also detailed external allegations, detailed allegations from whistleblowers pertaining to the same. So the agreement is we don't just look at everything. We look at specific areas that the committee believes are pertinent to look at.
So when would those be noted, Chair? Just so we're obviously going to approve the terms of reference sometime. So
just advise us here, where do we then, should we provide a more definitive sub-bullet in terms of what we're looking at, or how do we deal with that? Because it says alleged procurement irregularity. So when it says alleged, there has to be an allegation. Absent of an allegation, we're not going to go on a fishing expedition. I don't know if that's correct.
So, Chair, ideally you'd want to include a list. It doesn't necessarily have to be a closed list, but a list at least of the first 2 or 3. As I said, part of the inquiry is that it is an organic process and things would crop up as we're inquiring and as we gather information. But certainly at the point where we are inviting people to come and testify before the committee, we would need to put them in a position where they are aware on what the matters are that they're going to be questioned on and what they relate to. So if the committee is is able to provide more detail, we can certainly insert that now.
All right, thank you. So I think, Honorable Beasley, this is fine, because one of the things that may happen is that once we publish the terms of reference and somebody knows of an instance, they've got to be able to alert the committee in time. In other words, it encourages more whistleblowing. So I don't know if we can be definitive at this point. So let's leave it at alleged. Thank you. Thank you very much. Shall we go to 4.1? We're actually at 4.1.4. We're almost there. So the rough litigation costs between... So I would actually, especially in the context of the discussion we had, actually we need to start in the financial year 2020. Yes, we started 1 April 2020. And let's go all the way to the previous financial year, because December 2024 is nearly the end of the financial year, but there's a 3 months, so we need to cover basically 31 March 2025. Yeah, then it will be the most recent. I am just trying to think, and I'll come to you, Honorable Skhosana. So I'm just trying to think if we don't need to frame the rest of that sentence slightly differently. Okay, so we're looking into the rough litigation cost between 1 April 2020 and 31 March 2025. So when you say including wasted costs due to inadequate litigation, isn't that one of the issues that would arise? Shouldn't we frame that in a sort of a more... I mean, we are obviously looking at whether there was wasted costs and inadequate litigation, but we also had a discussion about whether the RAF also does not end up spending some of its costs are due to the behavior of external parties, inappropriate behavior of external parties. Or am I getting lost in the document myself? You understand what I'm saying? So that seems to be too limiting, in that the costs and so on is what we're looking at through the entire inquiry anyway. The waste. So in other words, where do we handle the allegations that there are people who are fleecing the road accident fund? Or is it point 3? Measures to curb inflated or unjustified legal claims and legal practitioner abuse. Would that cover it? Okay, all right. Okay. So I've noted, Your Honorable Neil May, there was a hand? On this point? Okay.
No, what I wanted to find out, Chair, why from 2020? Why don't we go back before these ones? Maybe a year or two back. I'm just throwing that to check, to see, to compare.
It's a 5-year period. Now, what the road accident fund is free to do is to provide such information on a background that may help inform the developments we saw in 2020. Otherwise, we can go back endlessly.
Why 20?
Because it gives us a 5-year view. It gives us a 5-year view.
What? So sorry, Chair, it's giving me a little bit of trouble. What I'm saying, why don't we compare the last previous one, maybe 1 year? I'm just suggesting that to say, will that cause harm?
So let's do it this way. So what we'll do is we will frame the information request in such a way that it provides adequate context to the information, because when, for instance, we're talking about the panel of attorneys in that part of the discussion, we said the Road Accident Fund would get an opportunity to say, this was the picture before. We looked at that picture and we reached the following conclusions. We then did the following, and this is the outcome. Already inherent in that is that they go prior to that decision. So nothing prevents them from doing that, because we've already said that that's what they have to do, because they have to explain the rationale of their decision. They can't do that if they're not allowed to go to the period prior. So they might say 5 years up to 2020, this was a picture, and then the 5 years that you're looking for, and now look at the 2. Yes, because it helps to explain the reasons for their decision. Yes. Okay, thank you. So if there are no further issues, we move to fraud, corruption,
Chair?
and... Oh, sorry.
Yes, sir.
Honourable Nilme.
Yeah, no, Chair. I just wondered if we could also probably look at what legal services the CEO himself has used defending himself in any matter.
That will come under legal costs. That will come under legal costs because therein is so if you remember in our discussion, we also are going to look at the cost of litigation that is unwarranted, or costs that are unwarranted arising out of legal action. So if you recall, there was even an instance, 2 instances of employees who've got appeal court orders to return to work. They are still not at work. They get, so we are going to get an opportunity to look at that breakdown. It will be in the information request.
Chairman, I just suggest on that first bullet point that speaks to the RAF's litigation costs and gives the period, we can just add the including wasted costs due to inadequate litigation management or unjustified litigation. And then that will cover that point.
All right, thank you. Honourable Skosan?
Yeah, the other issue which the legal advisor is raising, that sometimes, we feel that the chair is litigating because of whatever reasons. For me, I've got a problem with that.
Not this chair, right? You mean their chair?
Stand.
You mean their chair?
I'm just saying I've got a problem with that. That sometimes we are accusing people because we are sitting in a comfort zone to say why this person is litigating, and for me it's wrong. Point of order.
So,
are you doing point of order on me?
Yeah,
No. Chair, please, let's not start that again. No. Because so, we had the other gentleman. When I'm talking, you leave me. If you want to raise your point, don't come into my, because I won't get into.
There's a point of order. It's allowed.
So Honourable Skosan, members, can you switch off both your mics? I just want to intervene. I'm going to come to Honourable Dagmo. The difference between Honourable Dagmo and Honourable Beck is that Honourable Beck interrupted you. No point of order to the chair. Honourable Dagmo is doing it in the right way. To say I'm raising a point of order, we then have to hear him out.
No, thank you. I wasn't actually here when someone else rudely interrupted you, but I would assume that did happen. But no, my point of order was just to get clarity whether the honourable member, this reference to the chair, whether he's referring to you, chairperson, or the RAF, because I just thought my point of order would have been that if you're referring to this chair, that in terms of the way that you refer to him, it would have been out of order. But I'm happy to be clarified that you're referring to not this chair, but another chair. Thank you.
Yeah, no. Chair, I was just saying, when the legal advisor was saying that we must look of whether it's rational for people to litigate, because as I said earlier, for you might think that what I'm doing is wrong. But for me, I want to protect my rights. So I can go to the highest court But others will say it's wasteful. Wasteful for who? Because my life is at stake. I can take the matter to the highest court. Thank you, Chair.
No, so Honorable Skosana, we will get an opportunity to conclude as a result of the submissions made here. So we don't need to conclude the matter here. Yeah, people will make their submissions and will say, you know what, we agree. You were right. And then we move on. Honorable Atkinson, your hand was up.
Yes, Chair. I think we're going into the zone of the inquiry now. As the honourable member of the EFF said, we're merely looking at the terms of reference. We're not actually debating issues about what should and shouldn't be there, basically. So let's stop this and let's stick to the terms of reference. Thank you.
Thank you very much. Thank you very much. Honorable Skosana, we need to move on.
Why
are you raising an issue on the terms of reference?
Yeah, what I'm saying, I'm not talking something which is not on terms of reference. The legal advisor has made an input. So I'm allowed to make an input.
No, sure. Honorable Skosana, remember, I have dealt with the issue. We are now settled. We are moving on. So please switch off your mic so that we can.
The only problem which I have is when I'm making an input, then it's like I'm out of I'm not out of the term of reference.
No. So
I just want to emphasize that when I'm raising issues here, I'm not raising things outside the term of reference, which I have here. Thank you, Chair. Unless if the legal advice is giving advice, if there's an input or a different opinion, I'll raise my hand.
Thank you, Honorable Skosan. What I think is important, though, for everyone, and I've emphasized is in order for us to get through the terms of reference, it's important that we stick to the mandate of the committee. That's the point, the mandate of the committee. And anything that falls outside the scope of what the committee is allowed to look at, even if we are discussing the terms of reference, there's nothing, we are not empowered to do anything about an issue. But I take your point. Thank you. Can we then go to 4.1.5? We're almost done.
Sorry, Chair.
Your mic is not on, so the streaming cannot hear you.
Beg your pardon. Just with regards to 4.1.4, had we made a differentiation here between plaintiff and defendant attorneys?
Can we please switch off your mic? So the litigation costs in our guidance to them will deal with both. They will separate those both here. Okay, then we go to 4.1.5. All right, that's straightforward. Are we happy? Thank you. Okay, automations and claims processing. So this is Project Bukamuso is a project to install a system that, for instance, is going to, among other things, prevent the double payments. That system has been, the implementation has been going on a long time. The Road Accident Fund has spent close to $500 million on it. It's still not in place. The allegation is that it is behind. So that's one issue. In the second is the new claim form at the Road Accident Fund. Let me explain how that pertains to cost. So the cost in the first one is inherent. The second, in the explanation, the second, I need to just explain what that is. The effect of that claim form. So one of the things I have taken the time to do is to read some of the court judgments on some of these matters so that I can understand whether it is something that we need to look at or it's something that we should not. So that claim form has been declared unlawful by the courts on numerous occasions. The Road Accident Fund has been directed to relook the claims that were rejected as a consequence. Those claims remain unresolved, and people are waiting for some or other answer from the road accident fund. And the road accident, and those claims then go to court, and the road accident fund then incurs the cost of the litigation, but also the accumulation of interest. So it's important that we understand the detail of that issue, how it affected the operations, and the subsequent impact on costs for the road accident fund. So it's not there just as an operational issue. In the end, it has an impact on the finances of the road accident fund. So that is why it is A, the amount of money being spent. The contract is for over 860 million. The second is that it's A, not in place. B, there are these issues outstanding. All of those relate to claims processing. Okay, can we move on to governance and human resources matters? Oh, sorry, Honorable Beasley.
No, I'm on that one, Chair. Sorry.
On 4.1.7. Okay, please go ahead.
Yeah, Chair, it's just the use of RAF resources, and the word bully is probably the wrong word, so I don't know the correct legal term, but to bully staff and not to when court orders get issued to take the staff back, they just ignore them. So they're just using the legal process to wear down staff, and concern over that they're ignoring court orders to take staff back that have been asked by courts, and they're just using the legal process to tie them out.
So on that, there is bullet point number 4. Any other related matters raised in prior engagements with the committee? That's one of them. So, and I don't know whether we had 2 examples in the committee discussion, the previous committee discussion. One was the issue of Mr. Songelwa. The other one was the issue of Mr. Hlop. In both instances, the road accident fund has spent money on litigation. It's lost all the way, and it's likely to incur further costs on enforcement orders or opposing enforcement orders, when complying with the court order would be, and I think would be the better option, because the matter has been litigated to death. There is no other option now but to comply with the court order. I think in the ventilation of those matters, we will then deal with that. The second one is the impact of restructuring and high staff turnover on the financial management of the RAF. Inherent in that, for instance, so some of the information that will be in the inquiry bundle, as an example, is exit interview contents that people have sent to the committee explaining why they are resigning repeatedly, people in senior positions and so on, which ventilates some of these. Others have sent their resignation letters, etc., etc. So there's a bunch of information that arises out of that as well. So I do think it is adequately covered in there. Thank you. Ms. Ibrahim?
Chair, just a caution on the governance and human resources matters, that I know the line is very fine between what the PC on transport would do and what we would do, but our focus needs to be on the financial impact of these matters, and not to delve too much into HR matters as they purely stand. But I mean, that we will deal with as they come along, and the chair would just have to manage questions. So not to go into merits, for example, of these matters. Thank you.
No, thank you very much. In fact, there is a question that in the written exchanges between ourselves and the RAF. So there's a specific limited context. So one, there's that discussion about litigation that is pointless, where the road accident fund spends money. The second relates to the legal expenses. So that's one of the things that it will ventilate. So on the road accident fund's own telling, in the 1 year, for instance, they spent about 40 million on labor relations litigation, which also ventilates the same issue. So we're not going to ask people to send their grievances here. The third element is that the reason the exit interviews are important is because there are instances where people are raising specific governance and financial matters therein, which then trigger that we look at specific cases. So it's not looking at everything. It's matters that have got an impact on governance and the finances. Thank you, Honorable Skosan.
Yeah, thanks, Chair. Yeah, maybe just to cover the point that the legal advisor has raised in relation to the fact that our focus is more on financial implications on these matters. Maybe on that last bullet, maybe we can add, after saying any other related matters raised in prior engagements with the committee, and maybe say, and their financial implications. Because, for instance, on the issue of Mr. Songelwa, I think our interest is more on the fact that this person has been released to go and stay at home while his contract is still left with about 5 months, and then he is going to be paid while staying at home. While he is paid, it means somebody will have to act in his position. You see, so I think that's where we are interested as Scopa. Thank you.
No, thank you very much. I accept that guidance, actually, because that is the issue. It comes back to the use of financial resources and whether it is in line with what is allowed. Okay, then we go to 4.2. So 4.3 kind of is also the disciplining line. So the matters are complex in several areas. The focus of the evidence is, to how these matters have impacted the financial health and financial administration of the RAF. Please go on. So at this point, because we're going to go to format, can I just ask, are members satisfied that we've covered all the bases? Okay, all right. So we then go to format. So this is, I think under 5.1, that last sentence is very important. This is not a judicial or quasi-judicial process and is not adversarial in nature. It is inquisitory, which is covered in 4.2. I had dealt with that. And I think the legal advisor dealt with that issue of parallel investigations, which had been my apprehension in some of these. Sorry, just stay on 5.3. I just want us to be. Okay, yeah, I think that's self-explanatory. Okay, thank you. So let me just talk through a little bit through 5.5 because that's important. So the first one is that it's a member-led process. So with the primary inquisitors, like I said, there may be instances where we need somebody to explain something that requires particular expertise for the committee. So for example, when we get to the matter of legal costs, I'm making an example, we may need somebody from the state attorney's office who is sufficiently experienced to say to the committee, this is how the legal costs work, this is what this means, this is what that means, etc., etc. It enables the members then to ask the relevant questions in line with that explanation. To the extent that we can, I think you want as many of those experts to be from the state as possible, because then we don't need to pay people to come and give explanations as part of their job. So that is the first, and the second is questions C, which is important. Questions to witnesses will be subject to the reasonable restrictions of the chairperson, including imposing time frames and limiting or putting a stop to irrelevant or repetitive questioning. We'll traverse that when we get to it, but the important thing is that we really need to stick to the terms of reference when we make those inquiries. And that means even if we want to ask somebody about something that happened the week before, which falls outside the terms of reference, we will then need to leave that for an adequate time. So I may impose those kind of limitations on the conversation. D, may, if necessary, utilize external forensic and legal advisory services. May, as it becomes, but like I said, to the greatest extent possible, let us utilize state expertise and infrastructure where that's adequate. What we can't do is to ask the same people under questioning to also advise, obviously. Okay, so that's guidance on the invitation process. So point E is what I was referring to earlier, which is we will send, and I just need to make sure that I'm correct. So you don't from the get-go subpoena people. You make a request. You give them a reasonable time for them to provide the information. If they then don't, then you move on to the next step. May I ask that you just explain the process of getting to a subpoena, because I think that's important.
So, Chair, to subpoena or summon somebody is an extraordinary step because you're affecting somebody's rights. You're now forcing them to appear. So, rationality and the rule of law then comes in that you don't call people unless it's absolutely necessary to call them, and that they're sitting with information that the committee requires in order to perform its oversight. So generally the way the process unfolds, Chair, is that we first send an invitation where we would list the records that we would require and indicate to the person whether we would require them to come and testify in front of the committee. In other cases, it may just be that we require records and we don't need the person to testify. If the person does not agree to come forward voluntarily, and it's clear that their non-agreement is not just due to something like a clash in terms of availability. If it were a clash in terms of availability, that wouldn't be a reason for you to immediately go and summons. It must be clear that the person isn't willing to come forward. In that case, we would need, in terms of the Rules and the Powers and Privileges Act, approach the speaker for concurrence. So the committee resolves that they want to call this particular person before them. The speaker then grants that concurrence, and that then goes to the Secretary to Parliament to issue that summons. And there's a particular format that we follow. So it's quite a formal process, and that's then served on the person by the sheriff. So it isn't a case of you willy-nilly being able to change dates and times and so on. And you would need to be quite specific in that summons as to what exactly you require the person to come and account on. But we always start with the invite process, followed by a few phone calls if they don't seem to be eager to come and assist voluntarily.
Thank you. May I ask, so is the concurrence of on a case-by-case basis, so each time we then have to ask for concurrence from the speaker in the process that you've set out? Or can we send... I'm just trying to think about a case where some people or parties may want to frustrate the committee, and we just keep getting delayed in the work that we do. Do we request concurrence on each case, or can we get concurrence that when we can demonstrate that we've reached a certain point with each person, then the concurrence applies? I don't know if you understand what I mean.
Yes, so Chair, we have done that in the past. Generally, we would ask for concurrence in respect of a particular individual, and we would write to the speaker. There would be a memo that would come from yourself explaining the person's received an invite on this day, and these were the follow-ups that we've done, but they are still refusing to come. In other cases, we could send the invites out and then indicate to the speaker that we're requesting concurrence in the event that the following list of people do not want to voluntarily avail themselves, but on our side, that we would use our best endeavours to get them here voluntarily. Because the problem with this process is that it is quite time intensive. Because by the time you get all the memos done, it eventually ends with a memo to the SDP, who in turn must ensure that that summons gets issued. And then you've got the sheriff, that also takes time. And then lastly, you also need to give the person sufficient time, notwithstanding that they knew right at the beginning that you wanted them to appear, for example, on 20th of September. But from the date of the summons, you would need to give them a reasonable time in which to appear. So we can certainly try to draft those memos in advance and see if we can get the concurrence from the speaker. And that is going to be dependent on us having that complete list of persons. So it wouldn't be general to the extent of any person that we think is necessary.
All right, thank you very much. Look, at this stage, I am not aware of anyone who has said that they won't assist the committee. So perhaps what we do is we send the letters of invitation, and then thereafter we see who says, I want nothing to do with you, in which case then we can at least we've got proof that the person doesn't want to assist, and we might want to. I think maybe that's the best thing to do. Sorry?
Chair, one of the things we can do in that concurrence memo is to deal with the possibility that persons don't indicate that they're not going to attend, but they simply don't attend on the day, so that there is preparation and we are expecting them, and once we get to the committee hearing on a particular day, they know where to be found. So if we get that concurrence in advance for such a situation, it would mean that we could then immediately get that memo to the SDP. Thank you.
All right, thank you very much. Who's that advocate who went to run the comrades? We could, in the sense of Mayor case. Thank you. Shall we move on? Thank you very much for that guidance.
Sorry, Chair. Talking about the comrades, didn't the Road Accident Fund sponsor the comrades this year, if I'm not mistaken?
Honorable Neil May, we had a conversation about this, so I'm not going to entertain that question. Sorry. Okay. Point Roman numeral 2, submission of affidavits and evidence. Okay, I think that's clear enough. Oath affirmation. Yeah, I think that's clear enough. Roman numeral 4. So this is Roman numeral 5. I think it's important to just deal with it. And I'd please like to ask members, because I suspect there may be one or two. So this is an inquisitory process, so we're not going to have, that means we're not going to have lawyers speaking on behalf of people here, right? However, whilst any person may seek legal advice at his or her own cost, no legal representatives will be allowed to participate in the proceedings of the oversight inquiry. The chairperson at his discretion may allow a witness to reasonably consult with his or her legal representative during their appearance before Scopa. So let me just make sure that I understand. I'll come to you, Honorable Skosan noted that what this means is that the witness may, if they get asked a question that they believe may infringe on a right of theirs, basically confer with their legal representative, who would be, I assume, sitting next to them, confer with them to get some guidance on basically how to deal with the question that is allowed, right? So that's what that section means, or that point means.
Yes, exactly that, Chair.
And then do we then say that the person would then also say that, you know, either it would be okay for them to answer the question, or they might say, I am advised not to answer the question because they're under oath. How does it work? I'm just trying so that the members understand what they might be dealing with on the day.
So, Chair, you would need a reason in law not to answer. The Powers and Privileges Act says that witnesses need to answer fully and satisfactorily, and their failure to do so would be an offence. So there may be times where a person has a genuine reason why they can't answer. Let's say it's a question where the answer would reveal something in contravention of the Poppy Act, by way of example. They may say, well, I'm not willing to give that address or that ID number, but this is the extent to which I'm willing to answer. That would be a satisfactory answer and a satisfactory defense as to why you can't answer fully.
Right. Okay, no, I get that. Or tell me, are people allowed to say, if I answer that question, then it might incriminate me? Or I'm going by TV standards now because I'm a layman.
So, Chair, one of the reasons that we request that people take the oath is because it gives them protection in terms of the law, that anything they say in front of the committee under oath can't be used against them, except to the extent if they've perjured themselves, because that would be an offence in terms of the Act. But in other words, an official that comes here and says something, that information can't be used against that official in another process. So if the NPA were to be prosecuting, they would have to go and do their own investigations and not rely on what we've done, or what was said here, rather.
All right, thank you very much. So I get that. So they can't say, well, you said in the committee on the 28th of September. They're not allowed to do that. Okay. I think we'll need to explain these things to each witness ahead of time so that they also understand what their rights and obligations are in the hearing itself. Thank you very much. Honorable Skosana, your hand was up.
Thank you, Chair. I totally object that, Chair, that people should not have representative, because we normally quote this issue which I'm against, and I must say that the 11 people sitting in Braamfontein takes this decision, which sometimes leaves much to be desired. There was a constitutional court judgment about that. People are appearing on this inquiry here in Parliament. Not once, not twice. If one has to have a legal representation, it's his constitutional right. Or he can even be represented by a fellow employee. That alone cannot take away the procedural fairness. Now, if somebody says, we are coming into a person says, no, you know what, this got nothing to do. When you go to court, they won't use that. Let me tell you, we'll be sitting here, those people will be alone. If people want to use that in other way, not necessarily quoting us here, the inquiry here, they'll have the facts on the table. Why are we not allowing them to have a legal representation? Why? What are we hiding?
Please, I want to answer, so I need you to to switch off your mic. So I think you are being sabotaged there on that mic. Yeah, there's sabotage going on there. We need to deal with it. Now, Honorable Skosana, remember, legal representation is broad. So when you say somebody has got legal representation, and I look at the legal advisor here, it also means your legal representatives may also participate in the proceedings and ask questions and that kind of thing. This is an oversight inquisitorial process. They may not do that, okay? What they may do is to advise the client, to sit next to the client and advise the client on how to deal with questions. Now, that's a... But Honorable Skosana, I'm going to defer to the legal, but that's what the law and the rules say. We cannot change them. Otherwise, let me paint a scenario here. Because otherwise, in any other hearing that we have here, you could have a person bringing in their lawyer. and that lawyer wants to participate in the proceedings, I don't think, honorable member, you would like that very much, because that person is not a member of this committee. So what is allowed within the parameters is that that person is given the space to confer with their lawyer, which ordinarily doesn't take place. And the lawyer advises them on how best to deal with the question. And that is the exception that the rules make. Okay. Can I ask you, Ms. Ibrahim, to assist here? Did I get anything wrong in the explanation?
Okay, can I make a follow-up before? The legal advice knows what I'm talking. I don't want us to degenerate into that, Chair, because the issue which we are explaining here, the portfolio committee is not like the inquiry. There's two different things. Yes, a lawyer cannot come in and represent anyone here. But once you say it's an inquiry, the Constitutional Court has ruled on that. It's not me. And those people who wants to use lawyers, they will use lawyers if they want to. But what I'm saying, we cannot say they are not allowed. If one wants a lawyer to or an advocate for that matter, to represent him or her, we cannot say they can't.
May I, so I take your point. May I ask Ms. Ibrahim to just explain what the statutory, the powers and privileges, as well as the rules of the National Assembly say in this matter? Because that's what we can go with, and I'm sure that has regard for any case law that is there.
Chair, the rules and the Act are silent on this particular question. The manner in which the question served before the Assembly was in the context of the removal of a Chapter 9 head. And originally those rules, as adopted by the Assembly, provided that a Chapter 9 head that was before a removal committee of Parliament would not be entitled to legal representation. It was one of the matters that the former public protector challenged, and it went up to the Constitutional Court, and there the court found that she should be entitled to full legal representation. The rationale for that, Chair, would have been the fact that the consequences in that particular inquiry would have been very grave, because it is the Assembly that determines whether the person should be removed or not. So that was the rationale. This is a little bit different. As I said at the beginning, this is an oversight inquiry. Granted, it's heightened oversight in terms of the fact that it's more structured. It's a little bit more intensive than the way we would normally exercise our oversight. But the committee has no power at the end of the day to make any decisions in terms of criminal charges, removal of a person, to say that somebody's guilty of particular conduct. Those things would require referral to the correct fora to deal with. So the committee has no decision-making power. What you're going to conclude on ultimately is your views in terms of the evidence that was before you and what your recommendations are in how those things should be dealt with further. The question hasn't been tested for this particular scenario. It would be then no different, as you point out, to any other oversight exercise where government officials are called in routinely, and so is the executive to come and account. I would think it would be farcical to expect that every time somebody comes to account that they're allowed to have full legal representation, because then you would be bogged down in legal strategies that may be done in such a manner as to delay or frustrate or hamper the work of the committee, rather than going into the meat of the matter, which is to conduct that oversight. So it has not been tested. I think that the example in the public protector matter is certainly distinguishable because of what that end result was there, which could have been removal. Here there is no such similar grave step that can be taken by the committee, Chair.
Thank you. Honorable Skosana, the other Honorable Skosana had his hand up, and I will then make my views known.
Thank you very much, Chair. No, just to add on what the legal advisor has said, the Constitution, the Constitution says that the person Fortunately, I was part of the Section 194 inquiry into the fitness of the public protector to hold office. You see, the difference between that inquiry and this one is that that inquiry was squarely about the public protector. It was not about any other thing. Hence, the court said the public protector has a right to be represented because the inquiry, though in the inquiry would invite different people who are staff in the office, some they were doing some different stakeholders who were working with the public protector and other people who had cases with the office of the public protector, but it is only her who was given the right to have legal representation. All other witnesses had no legal representation. And the reason is that the inquiry, it was about her, whether she is fit to hold office. But another point is that if we allow people who appear before the committee to be legally represented, it means we must also appoint an evidence leader, you see, who's going to act like a prosecutor. And now, if we take that route of appointing an evidence leader, then you need money. That's where resources comes in, because we were saying we want to do this inquiry not to have cost to Parliament. We want to do it as a committee without using. But now, if you are going to have lawyers, then it means you must also have an evidence leader who's also a lawyer, because you can't have lawyers talking to the chair. There must be lawyer both sides. We need to have a lawyer who is an evidence leader, who will lead evidence, who will act more like a prosecutor in a court of law. And then have lawyers that are representing their clients. So you can't have a lawyer on one side, but on the other side, you are having the chair of the committee. So I think the circumstances are totally different, because we are not we're not going to determine the fitness of any individual, and we're not accusing any individual. You see, this is an inquisitorial process like that we have indicated. There's nobody who's been accused of anything by this committee. So if we're saying people, they've got the right to be legally represented, whom are we referring to? Out of all the people who are going to appear to this committee, who should be legally represented? Because in that one of the Section 194, it's only the public protector who was legally represented, because the whole inquiry, it was about her. But other people who were called in the committee, they never brought lawyers. Thanks, Chair.
Thank you very much. So, and I'll come to you, Honourable Scott, and I just need to, I may address the issue. Two takeaways from this, and we've made this clear, both in the terms of reference, but also in my letter to the committee, which is public and parliamentary record, which is why I wrote it in the manner that I do, that the objective of these inquiries, the objectives are set out clearly at the beginning. None of that says it is to find anyone guilty. We've said that clearly. That's the first thing. The second thing is that this is a member-led process, as Honourable Skosana has reiterated. It's a member-led process. It's an inquisitory rather than an accusative. It's not a judicial or quasi-judicial process, and so on. What I want to say to you, Honourable Skosana, now Honourable Skosana Mandla, is to say that because the legal advisor says this matter is untested, if there is any witness that wishes to challenge this, they are free to do so clearly. We can't, however, we should not change the rules on the off chance that someone unknown may be uncomfortable with what is on the table. So what we are accepting as a committee is that if there is a witness who wishes to challenge that part of the terms of reference, because it's an untested area, they may well do so. But I don't think we should then change the manner in which we want, because the implication relates to what you said earlier about cost. It relates to the length of process. It relates to the complexity of the process. And we want to keep this at the level of enhanced oversight by the committee and no further, and use parliamentary resources and use state resources, etc., so that we keep it here within the ambit of the state. I take the point that you are raising, but I think what I'm taking away is that if anyone wants to challenge, they may well do, because it hasn't occurred before. It's not our job to imagine that somebody will.
Thank you, Chief. But for me, I'm thinking about those people, those witnesses we are talking about. If they don't have the money like we have, which we don't have, is taxpayers' money at the end of the day, that we should not be thinking, we should not be naive and say, you know what, we don't care about what happens to the other person. For me, from where I'm sitting, I'm saying to you, Chair, I heard the legal advice saying, you know, it's silence. Let's not make it silence. Let's speak louder here about this matter, because we have a legal advice here who's paid by Parliament. Somebody who's not here must pay out of his or her pocket. Now, I'm saying that's my opinion. Remember, we are discussing here. I'm saying to you, Chair, for us to have an inquiry, because we've been dealing with the matter of ref for some time here, we want to conclude on this matter, which I agree. But let's be fair. Because if we are having an inquiry for the sake of inquiry, I was not talking about the public protector anyway. Because I don't think the inquiry was up. Listen to me, Chair.
No, I just want to actually get the point of clarity. When you say legal representation, what do you mean in practice?
I'm saying a lawyer. If one wants to use a lawyer, if he wants to use a lawyer to speak, let's not say the lawyer cannot speak here on the inquiry. No, not an advice. An advice is something. Advice is like when she's giving an advice now. I'm talking about someone who wants to use a lawyer.
Sorry.
What's wrong with that?
To do what? What would the lawyer do?
I'm saying, remember, Chair, you are going to subpoena those people to come to the inquiry. He wants to get a representation. A representation is a representation. You can't say to do what. A representation is representing him or her.
So Honorable Skasana, can I just, because this needs to be clear also to the public, please just, so if Mr. Bowman is a witness, they're coming to the committee to account for a particular issue. They bring their lawyer to sit here. Once Mr. Bowman is done, his lawyer lives with him. During the course of Mr. Bowman's testimony before the committee, apart from advising him on how to answer the questions, how to deal with the questions, what else would that lawyer be doing? What else would they be doing?
Chair, simple. Like we are sitting here. If a witness wants to use a lawyer, after he's finished with his evidence, he'll go or she'll go, and that's it.
You're not answering my question. What would the lawyer do during the course of because the lawyer actually plays an active role in this instance, in that you, honorable member, ask Mr. Bowman a question. Mr. Bowman asks the chair to confer with his lawyer, and the lawyer explains to him how best to deal with the question, because Mr. Bowman is a witness. And then once they've finished conferring, Mr. Bowman answers. That is allowed. I'm asking, over and above that, what is your unhappiness? What else would the lawyer be doing? Would they be asking the members questions? I'm trying to understand your apprehension here. What's the concern? And I'm asking genuinely.
My concern, Chair, is why are we not allowing witnesses to have a lawyer, a legal representative?
Okay. Maybe I'm losing it. They are allowed to have a legal representative sitting next to them. When they get asked a question, if they feel comfortable to answer it, they will answer it. If they need guidance from their lawyer, they will ask the chair for permission to confer with their attorney here, and they will be allowed to do so. Now I'm asking, apart from that, what do you imagine this lawyer doing?
The presentation I think it's on now. What I'm not getting from you, Chair, I'm talking about you now. Do you have a problem of a lawyer talking on behalf of the witness, and why?
So Honorable Skosana, in any hearing, in even a judicial commission of inquiry, it is always the witness who answers the question, never ever the lawyer, even in court. It never happens that the lawyer is the witness's representative, not his or her mouth. They may not speak on their behalf. They may, yes, I'm trying to get your apprehension because we're getting bogged down in the issue, and I am worried that you're raising an issue where that is already addressed. So the lawyer in any forum never substitutes the witness. It's always the witness who answers. Right. That's the first thing. In fact, in those hearings, they're not even allowed to confer generally with it. You answer the question. Your lawyer may object to the question and address it to the chair, but actually they just may not answer for you. Also because the issues at hand are not within the personal knowledge of the lawyer. The lawyer does not work at RAF. He or she doesn't know what happened. They were not in the meeting. Right? So what would ordinarily happen in court where you've got a judicial process, which this is not, is that once the witness is done, another witness, because they may lead their witness in evidence in a court of law. Here, the only people who question the witnesses are the members. They're the only people. And before answering each question, the person may confer with their attorney, and we wait. The lawyer has no other role in the proceedings. And I'd really like to propose that we move on from this, because the person, to the extent that they've got an apprehension about their rights, they are going to say so, because they'll speak to their lawyer and give a reason why they can't answer the question.
Because what happened before is starting again. Is starting again among us to say no. Chair, I'm not a runoff of a mill here. I'm going to present my opinion in this committee, and I'm within my right. No member must intimidate me in this committee. And if Darkmore has got a problem with that, to say no, why is I'm talking? I've got a problem with that.
So,
and I'm saying, Chair, wait, Chair.
No, Honorable Skosana, it's Honorable Darkmore.
Yeah, it's fine.
No. It's Honorable Darkmore.
Yeah, Honorable Darkmore must give me a chance, Chair. And if you are not pro-protect, I'll protect myself. And I'm going to say this. I'm not going to back down or being intimidated by anybody here. I'm raising my opinion here, honestly so. And I'm saying to you, Chair, if there's no problem, I think this 5 point, why you said that we don't need lawyers. There was a reason, am I right? There was a reason why there's this clause here to say.
Honorable Skosana, the reasons are set out, and I don't want this to be a back and forth. Please just kill your mic.
But can you allow me to finish, please?
You've asked me a question, I'm dealing with it.
I want you to answer, because otherwise it's going to be, I just want to say to you, Chair, is that all this, now there's talk, Chair. You know what? I normally don't like this, Chair.
Honorable Skosana, can
I respect people, and if people don't respect me,
Honorable Skosana, can I now deal with them? I need to now set this out, right? Because we're gonna need to move on. We had a similar discussion last week, and the agreement was members may whisper to one another, but they may not loudly interrupt another member. And whatever has been going on there is not raised to the level of interruption of what you're saying. So that is the first thing. The second thing, Honorable Skosana.
you are saying that because I'm hearing them.
Okay, so in that case, then you may raise issues. The point I'm making is this: we need to rule now on the issue because we can't discuss it endlessly. The terms of reference, we've gone past that issue. We agreed it's not a judicial process. It's not a quasi-judicial process. It's not to establish guilt of anybody. Those three, having agreed that the nature of this inquiry is not any of those, it then takes out the requirement for legal representation. It's inherent in us agreeing that that is so. You are addressing an apprehension that does not exist. And at this point, I then have to ask the members to say whether they agree with your assertion or not. And we take it to a vote, and then we proceed. We can't discuss it endlessly, Honorable Skozan. I have indulged you for an inordinately amount of time because I want also the public to understand why we're taking the decisions we are. But it's becoming excessive, I'm sorry.
It's fine. You are in charge here. But
But
I'm saying let's close it as you say. Let's not even go to vote, Chair. Let's not even go there because you know it's all about numbers. I don't want to go there, but I've made my if anybody in those people take us to court, don't say I never said so here.
No, noted. Thank you very much. Honorable Dagmo.
Chair, just to say that, I didn't mean to in any way interrupt the member. My concern simply was that as the chair, there seemed to be a dialogue underway and some of us just want to express a view. I think we've canvassed this particular point and, it's very clear that in terms of the formulation of 5B, that it's a clear thing that the representative, no legal rep will be allowed to participate. My understanding of participate is speak and all of that. And there's a clear provision there which says that the chair, in his discretion, can allow, as you've described, a witness to, to consult, to ask like, should I answer this or etc. So I think that's clarified. I would actually like to move, Chair, that we adopt the document before us so that we can move on. And that I would like to formally move that. I'm standing in for one of our members. As you know, I'm normally an alternate, but I'm standing in for one of our members. I would like to formally move that the committee adopts the presentation that we've been given and the guidelines for this inquiry. I think a lot of work has been done, and the terms of reference, I think, will not only help this committee, but in fact other committees who are confronted with having to do similar inquiries. So I formally now would, as an order point, want to move acceptance of the terms of reference.
All right, thank you. Honorable Nandanja.
I second the adoption of the documents.
Honorable Atkinson.
I would like to add our name, the DA's name to that, that we would like the report to be adopted. Thank you.
Can I just ask an order question? Are we not here as just ordinary members? I'm not sure if we should say if it's for the DA. I thought we just here as members. I mean, I can say I'm from the ANC.
You make a good point. Please restate that, Honorable Atkinson.
I ask, or I express my support for the terms of reference. Thank you.
Thank you. Honorable Matiwane.
Thank you, Chairperson. I think now we are deviating from the exercise that we're doing because we're going through the document page by page, and we have not reached that the last page where we would go to the adoption, because there are certain issues that we have not covered that we would have loved to raise issues on. So now if we are adopting, that means we're bypassing the process that we set for ourselves.
Thank you. So I was going to, thanks, Honorable Matiwane. So I was going to ask, in light of the proposal, because when the people were putting up their hands, I had no idea what they were going to say. So my question is the following. Having had regard for the document prior, and I know we're going through it page by page, is there anything that any of us want to raise specifically in the remaining part of the document, because I do think it's important that we're quite clear about that we don't have someone later on saying we didn't get an opportunity. So while we're not going point by point, is there a specific section here that you feel the committee needs to ventilate? And we've dealt with the issue of so that's a discussion we've just had now. Number 6 is opportunity to address adverse findings, and basically what that says is that when there's an adverse finding against someone, that will be communicated to them so that they can make the necessary representations to the committee to say, I disagree, and this is why I disagree, and this is where the supplementary evidence is that and then we have got an obligation to carefully consider that. That really actually is the last substantive point of this whole discussion. The rest of it deals with resources, which we have addressed, unless somebody feels our resources are not adequate, and then we'll adopt the motion. Okay, Honorable Matiwan.
Thank you, Chairperson. I wanted to raise an issue on 5.5.4 on partnerships. It is vague for me. I don't understand what role civil society or an academic institution may play in assisting the committee to conduct its work. Because if you look at the Constitution, Section 56 of the Constitution, which deals with evidence or information before the National Assembly, subsection D there says that you can receive petitions, representations, or submissions from any interested person or institutions. So if a civil society or an academic institution feels like they need to make an input into the inquiry, they should do so through representations or submissions to the committee, not to assist the committee. I have an issue with certain civil society organizations in South Africa that peddle a certain agenda. We might agree that we will have these partnerships, and it is not said prior to the adoption of the terms of reference which civil society will be partnering with as a committee. So if that can be clear, maybe even the legal advisor, parliamentary legal advisor can tell us if it's permissible for us to go into a partnership with civil society to assist the committee. Because if they want to make submissions, they must make submissions. In what form will their assistance be to the committee? We need to be assisted by civil society to do our oversight work as members of parliament.
So my reading of that, thanks for that, Honorable Matiwan. My reading of that is that we are not going to go out and seek their assistance. What may happen is that somebody writes to the committee and says, I want to assist you with a particular part of the inquiry. It is up to this committee to accept that assistance or not. Right? This can be a body that has got expertise in one or other area that is relevant to this committee. What the committee still needs to decide is whether we need that to accept that offer or not. So it's not something that we must do, one. Secondly, it is also not something that we are saying we will go and invite it, because it's not. So that's the first thing. The second part of my answer is a question to you, which is, am I to assume that you have no difficulty with academic institutions, merely civil society, because that's a whole section?
I have no issue with academic institutions. But when it comes to civil society, you know, civil society is funded by external forces, maybe some are not even based in South Africa. And then now when we are saying we are partnering as a committee with an organization that may be funded from outside of South Africa, then there is an issue. I have an issue with that.
So Honorable Matiwane, my answer is we may accept assistance. We are not going to go out and seek it. That's my reading of it. We're not seeking the assistance. Somebody may offer to assist the committee. It would be the decision of the committee whether we accept that assistance or not on its merits. In other words, a research organization that has conducted research in a particular area that we will be dealing with. They say to the committee, we have the following data that would be useful to the committee. I think we would also be failing there because they're not a directly affected party. We would be failing in our duty of public participation to say, because you are a non-profit organization, we are not going to accept the data that you are providing. I think what is important for the committee to do is to consider the merits of the offer of the assistance. And if we feel it is useful to our purposes here, we may accept it. If not, this is not a free-for-all. So that's my reading of it. If it's not going to be useful, then it won't. I made an example about an organization that wants to canvass another issue here. It falls outside the offer is rejected, right? So, but I do want to ask our if I have at least the framing of that, my answer in explaining that section 1, and secondly, the comment about public participation. No, yeah, let's just take that. I'll come back to you.
Maybe the wording is incorrect to say partnerships. Because my issue is with the word partnership. Because there's a difference between a partnership and someone making a submission.
Okay, so I really am not married to that term. If it achieves the same purpose substantively, I'm okay with this. So would you be comfortable with external assistance to the committee? Because an academic institution falls within the same category. It's not part of parliament. Now, Honorable Skosana, you are doing exactly the same thing we are complaining about with Honorable Doug Moore. No, but I'm saying. I'm not talking. No, hang on. So I'm saying, Honorable Member, Honorable Matiwane is exercising the same opportunity you did, right? Please give me an opportunity to deal with him. But you know what you said, and I'm not irritated. I'm just making the point that you said chair, right? No, it's not me. Oh, was it Honorable Kupek? So, okay, I'm sorry, I'm chasing you with an X when you are not guilty this time. So I'm giving Honorable Matiwane an opportunity to make a contribution substantively, and I'm asking the question. So, Honorable Matiwane, would then they say, if it said external assistance, right? And then Scopa may accept assistance from any civil society organization or academic institution that may be able to assist Scopa at no cost in conducting its oversight inquiry. In other words, this example that I'm giving to you, where somebody says, I have actually conducted extensive research into a particular matter. Here's the data, and I think it would be useful to the committee to consider. We consider the merits of that offer, and we say, actually, this information would be useful. Because that's the purpose. In the alternate, an academic institutions might have a professor, might have research and that kind of thing that they've got, in which case we accept the same. So I'm not married to the term partnership. The reason I wanted our legal advisor to also opine is that it might be that we've actually reached a convergence.
Thank you, Chair. I'm persuaded, and I agree, it should read external assistance. The reason why this isn't under the rest of the public participation is that this may not necessarily be in the form of somebody coming to present something orally or submitting something. The assistance may be even to our research and content staff, for example. So in our ESCOM inquiry, our state capture inquiry, we had UCT, Graduate School of Business business that played quite a huge role in assisting staff in that committee to gather information and to scrutinize that information. So that was what we had in mind. It may be that they get invited to do an oral submission or to hand something in, but the idea there was just assistance where necessary. And that would obviously be shared with the committee if there's a source of information that content or research has relied on, Chair. Thank you.
All right, thank you very much. So we are agreeing. So she said she's persuaded. I said I'm not married to the partnerships thing. We can change it to external assistance. And the nature of the external assistance is quite clear. So there's not somebody co-running this process with us. If you've got information or insight that would be useful to the committee, and I've made the examples, that person is free to provide it. It's up to us to decide whether we're going to accept it or not. Does that serve your...
I still have an issue with the word assistance. I don't know if we can say may accept external submissions, not assistance.
Okay. Ms. Ibrahim, let me just ask, would substituting assistance for submissions still serve the purpose or not? I don't want to just...
So, Chair, what we had in mind here is to piggyback, for example, where somebody may have resources that could assist the content advisors and the research team. So as you said, we're sitting with data, we've done some studies, we've got some statistics and so on. So that may not necessarily be in the form of a submission, or we need some advice on how a certain process works, or the extent of a legislative requirement, for example. So that is what was in mind over there. But if the committee is not satisfied, we can take it out and limit it to submissions, in which case it's then not even necessary. It would form part of public participation then.
Okay, because I'm really not, I mean, there's nothing turns on this for me. What's important for me is that the committee gets the quality of insight and information that it needs in order to reach an outcome that is useful to what we are trying to do here. So that is my apprehension. And therefore, if we are able to get that information and we don't need to pay for it because it is available, we must be able to get it. We just may need to do that with people who are not directly affected. Academic institutions fall within that category, as an example. Research institutions fall within that environment. I don't think you are saying that we should close off that information at all. I don't think what you are saying. What you are nervous about is that somebody may inappropriately influence the process. That is your apprehension, right? So I think that what we can do is to say the scoper may accept submissions or data, okay, from any civil society or academic institution. In fact, let's just say civil society or academic institution, right? Let's take out organization. That may be able to assist the scoper at no cost in conducting its oversight inquiry. And that means we might go to a body that collects certain statistics to the extent that we need those statistics and that they are useful to the committee. So does that satisfy your concern?
And we do away with the word partnership.
No, it's off. It's been removed, yeah. As I said, nothing turns on it for me. It's what matters for me is the substantive purpose thereof. Is there, since we are on you, because I want us to finish, is there any other area that you are concerned with, Honorable Matiwan? Because that was a question.
That was the only part.
All right. Thank you very much. Honorable Kupeka, in fact, Honorable Madlala, you haven't had a chance. I'm not skipping you, colleagues. Honorable Madlala has not spoken.
Thank you, Chair.
To the question that I asked.
It's as if you knew that I was going to start with a political lecture.
But maybe let me start with the question and then end with a comment. The question would be, you'll forgive me, I came a bit late. If there was consultation with the portfolio committee, in terms of the functions of the portfolio committee, some areas may be overlapping, and I think part of the rules makes a provision that there should be that consultation. And also if a joint committee process would have been considered, because I think both the standing committee and the portfolio committee are faced with this heated discussion, so that we maybe avoid a situation where in future they have to then again have another inquiry of their own to deal with the same witnesses and the same processes. I think it would be cost saving. That is the question of the possibility of that, and what would really be disastrous about considering that. As a comment, firstly, I do not object to this process, and they said we're not here as parties, as political parties, but as members. Well, I don't object it primarily because I don't think there's anything revolutionary about it. I don't think that academic institutions are immune from the neo-colonial project and the capitalist agenda that is engulfed in this country. I think we're engaged in an exercise that I can almost tell you at a political level how it's going to be concluded. So as an individual person to sit here and reject would be part of the reformist, attitude to try and play within the box. There are many issues at play. I did say it in the last comment. I'm just putting it on record as a comment. There are many issues at play, administrative, political, and otherwise issues on this subject matter. And as far as big corporates are involved in this country, in as much as the effects of RAF could not be affecting 80% of the population, but it affects those who own the commanding heights of the economy, those who participate in ensuring that they maintain the status quo. And that is why we are having this huge hullabaloo around the matter. That is my own political conclusions on the matter. And we are now playing around the system to say what would be just and what would be unjust to present to or to inquire about in this process. Whether at an ideological or at a revolutionary level, we believe that RAF in its existence does require to be reformed or to be transformed. Is a discussion that I don't think many of the parties or many of the participants are willing to answer to. Civic organization also is the same issue, and which is why I concur with the latter speaker that if no matter how much we rephrase the concept of how we bring them here, imagining that there are individuals who are immune from the bigger and broader political and socio-economical issues of this country would really be acting out of ignorance. And whether when we interrogate them, we want to arrive at a point that, well, besides the information you are giving us, how do we verify it? How do we vet it? How do we vet your interest? Beyond it, where do you derive your existence? And what agenda do you drive in terms of the political issues of the country? And where we come from historically, where we are, and how do we see the future? And imagine civic organization as progressive. And progressive, not in the Adam Smith or in the modern term, but in the reality of the African context. How do we see them participating in a role of transforming the society to equality, to equal share and equal economic distributions? So it's a broad discussion that we could not finalize here. So me sitting here and objecting is still playing part of the game. So we'll allow the process to continue. That is my own view. But I just wanted to get that angle that says, can we not have a joint process, finalize this matter, and have it concluded? And I think that's the question to the chair. Those who are nodding are trying to, I don't know to do what, but I'm not going to raise my voice to them. Thank you.
Thank you very much, Honorable Madlala. I think the political discussion we can have at another time. So I have taken care to actually write to the Portfolio Committee on Transport, the chairperson. I need to check with the committee. Have we received a response? No. So I will write to the chair again following this conversation. So we might well end up with a situation, but I wrote to the chairperson even after our initial hearing with the, our May hearing with the RAF. I actually sat down and wrote a detailed letter to the chairperson of the Portfolio Committee on Transport. So It's not for lack of communication or transparency on my part. It is up to the chair in terms of their program to decide whether. So that's the first thing. The second thing, which is the part where you were still trying to get here, we have been at pains to say we are not the Portfolio Committee on Transport. The issues we will deal with here have to, in the end, deal with the mandate of this committee itself. One of the reasons is that I've also had no response from the portfolio. I cannot speak on their behalf and conduct a process that involves them when they've got their own program they want to drive and might not be interested in what we're doing. But for completeness, I will, once we're done here, write to the committee and be transparent with them once again and say this is where we are in the matter and this is how we're proceeding. So I've taken the care to do that. Yeah, thank you. Ms. Ibrahim, I'll come to you. No. Remember, Honorable Skosana, the reason I'm going to Ms. Ibrahim is because she might have something important to say to Honorable Matlala's point.
Chair, the rules recognise that there may be these grey areas, and Rule 248 provides for notice to Portfolio Committee where the scoper is going to be dealing with a matter which might fall within that portfolio. This is one of those examples where there are these grey areas. So once this is adopted, that formal notice can be served in terms of Rule 248, Chair. Also, Chair, just to mention that in terms of the rules, any member may attend any committee and may participate in the proceedings of any committee. They won't have rights to vote on that final report, but nothing would stop any member from that committee from participating.
All right. Thank you very much. Honorable, I can't remember now, so please forgive me. I'll just go. I can't remember whose hand was up first. Let me give you Honorable Skosana, then Honorable Kupek.
Yeah. Chair, I was a bit disturbed earlier, and I must say that here that this report was already accepted. There was a seconder on this, but anyway, you came back again that we must finish this because we're not finished. But I'm surprised that there was that acceptance of this, which leaves much to be desired. That whatever we are doing is a formality. That the report, not in fact the report, I mean the terms of reference was not even finished, but it was already seconded. That, you know what, as it is. But let me come back to what my colleague raised there. For me, from where I'm sitting, I've seen Steinhoff wanted to help NPA, whilst the NPA was investigating itself. The civil society, they don't need money anyway. They've got money because most of them are sponsored. I can give you 5 names who are going to come here, and I can put my head on the block. They will be here. I can put my head on the block. They will be here. They've got interest here. As my colleague has already said, that the system itself is problematic. We can say whatever we want to say. Rule 248 of the National Assembly rules. Some people will say we did not follow that. The scoper deals with, in particular, annual reports. That's what we're supposed to deal with. And the HESA report. But, as it may, Chair, the accounting policy must not be left out of this inquiry. Because we are going ahead now. We agree, even if I don't agree, it's okay. In terms of Rule 226, 1C, this investigation falls within the powers of the Portfolio Committee. But we said that earlier. Be that as it may, Chair, even if it says external assistance, you said, you know, perhaps we'll get universities interested here to give some facts and some facts on the matters which we are going to ask from the witnesses from REF. But the issue is that from where I'm sitting, Chair, the issue of civil society for me is a no-no. And indeed, I know we'll differ on that, But I can tell you whether partnership or whatever name we are putting it here, because they are loaded. That's where you're going to see what I was saying to you, that somebody is going to go to court and ask for that legal representation. Whether the court dismiss that matter or whatever, but that's going to happen. For me, Chair, I don't want to go into those numbers to say, irrespective of what we are saying, we are the minority. Whatever I say here, it's not going to hold water. So let me not even go there and waste my time and say I'm rejecting this, because it won't give any difference. Decision is made. Whilst we're on 5.1. Thank you, Chair.
Thank you, Honorable Skasan. I just need to make a correction here. So there was a proposal which was seconded to accept the terms of reference. I, as chair, felt that we need to be certain that the members understand what they would, and to the extent that anybody has an objection, we deal with it. Honorable Matiwane here did not need to rely on numbers. He raised an issue. We dealt with it substantively. We made edits to the terms of reference. As you saw, you were here. And I think that should give you the comfort that this is not about numbers. So that's the first thing. The second thing is that the issue of the accounting policy, you may have missed it. It will be part of the proceedings. We discussed it earlier. So if that's what you were referring to, so it's not skipped. It's in. Honorable Beasley raised it earlier on. Honorable Kupega.
Thank you, Chair. Chair, on 5.5.4. I 100% echo Honorable Matiwane's input, especially when it comes to assistance and or submissions from any civil society. Chair, we all know this is South Africa. Civil society is weaponized. When they come here, they will come here and they will put up a posture or a position of certain individuals, companies, your, dare I say, your discoveries, your Gertnel behind us, and we all know what they will do. So from MK Party's perspective, and I have concurred with my colleagues here, we reject wholly anything that has to do with civil society coming here to assist us with anything. As far as we're concerned, we do not need any civil society interaction here. If we have academic institutions, I'm sure those would be welcome. But civil society, Chair, we reject it 100%. Thank you.
So that's noted, Honorable Kupeka. I just want, on a point of clarity before we conclude, that any member's discomfort with any sector of society is superseded by Parliament's obligation to public participation. It is not legally permissible for Parliament to say you are this type of organization and therefore you will be precluded from participating in a process. I think while in political terms, I get the concern, we had a sufficiently substantive discussion for us to explain what kind of assistance is at play here. I note your point, but it's also important for the public to understand that Parliament has a supreme obligation to public participation. However uncomfortable anyone may be with any organization, it is constitutionally not permitted for Parliament to say, we have made a subjective political conclusion about you, and you are not allowed to participate in the processes of Parliament. It's something that we can't do, but your views are noted and they are on the record. Honorable members, may I ask, Honorable Neil May, because I was going to say then, subject to the issues raised here that we've now dealt with in the edits, can we then accept the terms of reference as they are?
Well, seeing you asking that question, Chair, yes, from our side, we accept the terms of reference and the latest input that you yourself have come up with as a solution. Thank you.
All right, members, the move was proposed, seconded, and reiterated again. Can we then adopt the terms of reference?
Chair, yes, I suggest we adopt.
Yes, Chair. Thank you.
Yeah, of course. Honorable Mandlala, you know me. I give people chance.
thank you, Chair.
I even run over and we get into trouble.
No, I wanted to say it seems that there is a spokesperson, so you may just ask Honorable Neil May. He said from our side, so maybe in terms of adoption, you can just say from their side also.
No.
The position.
The reason I'm taking people seconding is because I need to get a seconder. So our side on its own does not suffice.
Sorry, I just want to interrupt. From our, let's say, Honourable Skosana had to leave, and he did mention we did speak before he left the room. So between Councillor Honourable Skosana and myself, we'd like to accept your proposal.
Okay.
Thank you.
No. Thank you. No. I know, and also Honourable Skosana had notified me in writing that he has another meeting to attend, and Honourable Dagmore is his alternate in the committee. So, Honourable Skosana?
Yeah, thank you, Chair. As I said earlier, this was long accepted, Chair, before we finish, whilst we were on number 5. So it's just a formality. We as I said earlier, there was a proposal, it was accepted, and accepted again. And until Matiwane, our colleague, said something. But for us, we are very, 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 very clear. Chair, it doesn't matter whether we accept or not. This thing has been already decided, done. Thank you.
Noted, Honourable Skosana. Honourable Dagmore?
Chair, now, my understanding is that there has been a proposal and a second and no objections, but I just wanted to address you on one issue. I mean, you've raised this issue of civil society. To be very honest with you, I'm very interested to hear a critique of which private sector influence over this whole area. The issue of the legal profession, the issue of the healthcare, insurance, etc. So, I mean, I'm not just addressing this to honourable members who spoke before, but I think all of us, if we have information about, people who are conducting themselves in anti-competitive behavior or undermining this whole issue. I've said before on the Zoom that my own view is that we need to move towards a no-fault principle. Now, we're obviously not going to deal with that in this inquiry. But, there's an AfriForum, that's a so-called civil society group. There are black management forums. There are different organizations. And I think it is our responsibility to also push diverse organizations from civil society and the corporate sector and the business sector to come here and tell us what is actually wrong in RAF. Is it because it's been controlled somewhere? I'm not one for conspiracy theories, but I'm looking forward to this inquiry where we really understand the issues around who's actually controlling this particular board. So I think we should go out there and really get everyone to come here and tell us, in their view, what is going on here. And I think we should treat it in that way.
Thank you very much, Honourable Dagmore. So one of the things we'll do is we'll publish the terms of reference. We're obligated to do so, and also provide an opportunity to members of the public, and those may be natural persons and juristic persons, to make submissions here. What the committee then has to consider is whether the submissions fall within the terms of reference or not, but that opportunity will be provided. And I check everything with the Parliament Legal Services before I communicate, and I'll check there too as well. So there will be an opportunity for public participation or for submissions, basically. Thank you very much, honourable members. We adjourn.